Ryan Reynolds is asking the federal court to dismiss Justin Baldoni's lawsuit against him. His attorneys are alleging that Baldoni's complaint, his amended complaint, does not state any legally recognizable claim against Ryan Reynolds. So Ryan Reynolds is saying in the introductory paragraph of his motion to dismiss that he is nothing more than a supportive spouse who's just being there for his wife, who allegedly experienced sexual harassment from Baldoni. But Ryan Reynolds says that that does not give Baldoni any legally recognizable claim against him. And he points out that, Baldoni's attorneys are trying to litigate this in the media. He likens their pleadings to like gossip rags, and he's saying, okay, he's providing all these quote receipts and text messages, but they're highly redacted. They're just excerpts from text messages, not the full story. And he's saying in order to proceed in this court of law, Justin Baldoni is required to meet certain legal elements. And Ryan Reynolds' team says that he has not done so. So they're asking the New York federal court to dismiss Baldoni's defamation suit against Ryan Reynolds. He's saying that, Baldoni has hurt feelings over this whole issue. And, he's got this feud with my wife, Blake Lively, and he's pulling me into this. So it's a really interesting pleading here, this motion to dismiss. So we're going to go through it on the screen here. They actually did a full memorandum of law in support of their motion to dismiss. They cite a lot of authorities. And when we say authority in the law, we mean like he's citing to a lot of cases that have been decided in courts before him. He's also citing to a number of different statutes as well, and court rules as well. So in the introductory paragraph, which is really where the attorneys lay out their high-level overview of the case, and in an introductory paragraph, you really want to try to compel the court to give your strongest reasons as to why the court should rule in your favor. So this is what Ryan Reynolds is saying. He says Blake Lively sued Jamie Heath, which is Justin Baldoni's partner, Justin Baldoni, It Ends With Us Movie LLC, Jennifer Abel, Melissa Nathan, and those two ladies were involved with the PR for Justin Baldoni, Wayfarer Studios LLC, which is Justin Baldoni's company, and Steve Savowitz, the Wayfarer parties, after they collectively launched a retaliatory social manipulation campaign to destroy and bury Blake Lively because she privately spoke up about sexual harassment and inappropriate conduct that she and others experienced on the set of It Ends With Us. So this is an important point to say at the outset, is that I think a lot of us are forgetting that this case is not just about the alleged sexual harassment that Blake Lively claims Justin Baldoni did. It's also about what she says happened after the alleged sexual harassment. She is talking about a smear campaign and alleging that Justin Baldoni, who does have Steve Sarowitz, who is a billionaire, he has the money to back a smear campaign against her. That's her allegation. And she's saying that Steve Sarowitz vowed to spend $100 million to bury her and to create false press about her and really ruin her reputation and harm her. So as she continues here, as Ryan Reynolds' lawyers continue, they state that, so what does Ryan Reynolds have to do with that, legally speaking, other than being a supportive spouse who has witnessed firsthand the emotional, reputational, and financial devastation Ms. Lively has suffered? Nothing. Mr. Reynolds is a defendant in this action for one reason, and one reason only, because billionaire plaintiff Steve Sarowitz promised to spend up to $100 million to ruin Ms. Lively and Mr. Reynolds. The first amended complaint that Sarowitz and his co-plaintiffs filed seeks to fulfill that promise by polluting this court's docket with hundreds of paragraphs of clickbait designed for an audience other than this court, with virtually no bearing on cognizable legal claims. So to break it down, this means Ryan Reynolds' lawyers are calling it out right at the outset. They're saying, Your Honor, in order to succeed in a court of law, the pleading has to state all of the elements of each cause of action. And he's saying they have not done that. He's saying this is not some, gossip column where you throw out all of these personalized text messages and try to influence the public. This is a court of law where they do have a legal burden that they have to meet in their filings, which is in your initial filing, you have to state a claim. And when you say, I have stated a claim successfully, that means that you've alleged each element of the cause of action. So, for example, in contract cases, we have a duty. There has to be a duty, right? An obligation of one party to the other. There has to be a breach of contract. Then there has to be causation, meaning that the breach of the contract or the breach of the promise resulted in the harm. And then there also has to be damages, that the person who allegedly was the victim of the contract breach suffered some harm, right? That's recognizable. That's quantifiable, right? And there are other types of harm that are recognized under the law, different types of cases like emotional distress and things of that nature. But there are basic elements of a claim, and it can be very persuasive in a motion to dismiss to basically go after gaps in the other party's filing and say they did not even allege, element C out of the A, B, C, and D that they have to allege in order to state a claim for a particular cause of action. So, in this case, it's defamation, right? So there are certain elements that Baldoni will be required to prove in order to get a civil judgment from Ryan Reynolds for defamation. And remember, we're at the initial pleading stage. So that means it does not mean that you have to prove anything at this stage. The proofs come later. You do have to meet your burden as the case goes on. And there are different stages of litigation. We're at the initial pleadings, and this is an initial motion to try to dismiss Baldoni's claim by saying, listen, he doesn't even state a legally recognizable claim against me, right? So Ryan Reynolds' attorneys go on to state the Wayfarer parties have described the First Amendment complaint as their most recent attempt to put, quote, all of the evidence before the court and the public, end quote. That is a daunting concession, given the lack of any actual evidence supporting any legally cognizable claim against Mr. Reynolds. The Wayfarer party's so-called receipts include annotated excerpts, many with heavy redactions made by some unidentified person, of emails, text messages, videos, and photographs, such as large colored photographs comparing Mr. Reynolds' long hairstyle in a movie with Mr. Baldoni's long hairstyle at some point in his real life. But the First Amendment complaint is a pleading, not a gossip rag, and these so-called receipts fail to establish the requisite elements of a single one of the many causes of action alleged against Mr. Reynolds. That's a very persuasive point to make up front, is to remind the court that even though Brian Freeman and the Baldoni's team of attorneys has been trying to litigate this in the media and in the court of public opinion, we are operating in a court of law, and they do need to meet their legal requirements to properly state a claim in order to survive a motion to dismiss. So, and motions to dismiss are often not granted, right? Because the court does have great discretion at the initial stages to allow for continued amendments of the complaint. For example, Baldoni has already amended his complaint previously, and the court can say, I'm going to give you leave and I'm going to give you time to go ahead and amend your complaint again to state missing elements of a claim. Courts do tend to be more liberal about that at the beginning stages of the litigation, so as to allow claims to get on to the next part of the process, which is the discovery. So next, and it's really important here, I think, that they're calling out the fact that they have included Ryan Reynolds in this lawsuit. And there's a lot of conjecture and speculation about like what Ryan Reynolds' alleged motive or, was in this case. But they're pointing out the fact that there is, what is the evidence? What is the evidence that they have set forth that really would state a legally recognizable claim? So the entirety of plaintiff's defamation claim appears to be based on 2 times that Mr. Reynolds allegedly called Mr. Baldoni a predator. Okay. So they are saying the Wayfarer parties attempt but fail to assert 6 causes of action as to Mr. Reynolds. Each fails to plead facts that are sufficient to establish a prima facie case as a matter of law. For example, the plaintiffs collectively assert a claim for defamation without pleading a single complete statement or identifying the time or place of such statement, nor can they, because no such defamatory statement exists. Further, the entirety of plaintiff's defamation claim appears to be based on 2 times that Mr. Reynolds allegedly called Mr. Baldoni a predator. But the First Amendment complaint alleges no plausible facts that suggest Mr. Reynolds did not believe this comment to be true. Instead, the relevant First Amendment complaint allegations suggest that Mr. Reynolds genuinely, perhaps passionately, believes that Mr. Baldoni's behavior is reflective of a predator. Even if the First Amendment complaint plausibly alleged that Mr. Reynolds called Mr. Baldoni a predator while believing the opposite, which it does not allege, the law establishes that calling someone a predator amounts to constitutionally protected opinion. And the First Amendment complaint's thin-skinned outrage over a movie character, the satirical, quote, woke nice pot pool, does not even pretend to be tied to any actual legal claims. Instead, it falls into the First Amendment complaint's general allegation of hurt feelings, which in reality is nothing more than a desperate effort to advance the same curated bully image that the Wayfarer parties created and disseminated in the retaliation campaign they launched against Ms. Lively in August of 2024. So let's unpack this. As we know, there was that movie, Deadpool, where it's been so overplayed on social media, the scene where Ryan Reynolds has his long hair up in a ponytail, and people have speculated that he's making fun of Justin Baldoni. He's talking about how, Justin Baldoni, he's talking about, I've made my, profession, I've made my career being sensitive to women, et cetera, which Justin Baldoni has espoused to be for his purpose of his career. So, they're suggesting that Ryan Reynolds was doing a spoof on Justin Baldoni and making fun of him. And some have even gone so far as to say, well, why would he do that? Like, if you really believed that your wife had been sexually, harassed by him, why would you make fun of it? So then they're saying, hey, look, Mr. Reynolds, he may have genuinely believed that Justin Baldoni's actions were predatory. And they're saying he has a right to state that opinion, right? Because opinion is, whether something falls as an opinion or as a fact, is very important in a defamation case, because if it is an opinion, that's a protected type of speech, right? So then it says, all the other claims fail for similar reasons. The Wayfarer parties say that Mr. Reynolds extorted them, but failed to allege that he received any money or property, right? So typically extortion would be associated with, receipt of money, receipt of property. They claim that he interfered with a contract without identifying what that contract is, what provisions were allegedly breached, or even which of them were parties to it. They assert $400 million in damages, without explaining anything about who suffered that loss, in what proportion, as a result of which claims, or what proximately caused such losses. So Ryan Reynolds' team is categorically going through, these are the claims that Baldoni is asserting, these are the legal elements so that he must allege, he has to claim that facts, he has to state facts that are sufficient to constitute these elements of this cause of action. Okay. So the First Amendment complaint is long on hyperbole, prose, and claims, but devoid of any facts that are necessary to state ones that are recognized by law. It is, in essence, a burn book filled with grievances, attempting to shame Mr. Reynolds for being the kind of man who is confident enough to listen to the woman in his life, and to hold her anguish and actually stand with her. First Amendment complaint is, in sum, a textbook retaliatory slap suit, and it should be dismissed with prejudice. So this is really interesting. They're calling Justin out, and they are in attacking what Justin Baldoni stands for. So Justin Baldoni has built his career on claiming that, men, we need to do better. We need to listen to the women in our lives, right? We need to, put aside our feelings of having to be macho or overly masculine, and be more sensitive. And in fact, Nick Viall on the Viall Files, regardless of how you feel about Nick Viall or not, he's gotten a lot of flack about being very team Ryan Reynolds, very team and pro Blake Lively. He's openly stated that he's met Ryan Reynolds before, but bottom line is that Nick Viall has pointed out, and he has played one of Justin Baldoni's TED Talks where Justin Baldoni is saying that as men, we need to, listen to women, even if what they're saying is against us as men, right? So I can see that the lawyers for Ryan Reynolds are trying to bring in that sentiment here. And they're saying, hey, look, Ryan Reynolds is standing by his woman. He's standing by his wife, and he's listening to her, and he's empathizing with her. And now he's being penalized and retaliated against by Baldoni for doing that. So the background here is that the Wayfarer parties have asserted a grab bag of claims against Ryan Reynolds in their First Amendment complaint, including civil extortion, defamation, false light, invasion of privacy, intentional interference with contractual relations, intentional interference with prospective economic advantage, intentional interference, negligent interference with prospective economic advantage. The Wayfarer parties claim that they have suffered no less than $400 million in compensatory damages, plus mental pain and anguish, and severe and serious emotional distress, not to mention, quote, hurt feelings, for which they post they deserve additional compensation. So they posit that they deserve additional compensation for these hurt feelings. Despite its length, the First Amendment complaint alleges only a few isolated acts by Mr. Reynolds. With respect to the defamation claim, the First Amendment complaint does not plead a single complete statement published by Mr. Reynolds. The only hint about the purported statements that are alleged to form the basis of the defamation claim is the following assertion in paragraph 325. So let's take a look at the recreation of this paragraph here. So in paragraph 325, Justin Baldoni says the Lively parties made one or more statements to persons other than the Wayfarer parties, including without limitation to the New York Times, to the effect that the Wayfarer parties engaged in, permitted, and or failed to prevent sexually inappropriate conduct toward Lively and others, and that the Wayfarer parties retaliated against Lively and others for reporting the alleged sexual misconduct, including by preparing false and misleading narratives about Lively for the purpose of damaging her image or reputation. Only 2 allegations in the First Amendment complaint even generously match that description with respect to statements purportedly published by Mr. Reynolds. Quote, her publicist, Leslie Sloan, went so far as to propagate malicious stories portraying Baldoni as a sexual predator, a term Lively's husband, Ryan Reynolds, also used to describe Baldoni when he called Baldoni's own agent. Baldoni later received word that during the premiere of his movie, Deadpool and Wolverine, Reynolds approached Baldoni's agency, namely an executive at WME, and expressed his deep disdain for Baldoni, suggesting the agency was working with a sexual predator, a phrase that uncoincidentally later appeared in the press, and at a later date demanded that the agent drop Baldoni. So those are the 2 statements that they're alleging came from Ryan Reynolds. Apart from these 2 statements, the totality of the First Amendment complaint's allegations against Mr. Reynolds are that Mr. Reynolds demanded that the Wayfarer parties publicly apologize for so-called mistakes during production of the film, was present during a meeting at the apartment that he shares with Ms. Lively, at which he praised Ms. Lively's version of a scene in Mr. Baldoni's presence, allegedly contributed some writing of his own to the script, admonished Mr. Baldoni for asking about Ms. Lively's weight, and demanded that a scene be removed from the movie. Attended a meeting with Ms. Lively to address her allegations of sexual harassment on set and demanded that Mr. Baldoni apologize for his conduct, unfollowed Mr. Baldoni on social media, and included the nice pool character in Deadpool and Wolverine that the First Amendment complaint alleges was meant to satirize Mr. Baldoni's persona as a, quote, woke feminist. So those are the things that he is saying. Ryan Reynolds is saying, hey, those are the allegations that you've made about me in your complaint, Justin Baldoni, and those do not constitute legally recognizable claims against me for defamation. So the legal standard. In reviewing a motion to dismiss, the court accepts all factual allegations as true and draws all reasonable inferences in the plaintiff's favor, right? So Ryan Reynolds is the defendant in this case. He is the one who has been sued. The plaintiff parties are the Wayfarer parties, which is Justin Baldoni and his team, right? All of those other individuals, PR people, his partners. So essentially, the court, when they're deciding whether to dismiss Justin Baldoni's claim against Ryan Reynolds, the court has to construe all factual inferences in favor of Justin Baldoni. Okay. And once they do that, they say, okay, but if he still does not state a legally recognizable claim, we can dismiss this. And a lot of times motion to dismisses are not granted. I mean, I would say it's more often rare that a motion to dismiss the case is thrown out at the outset, because courts, especially like from my experience, like I've done work in federal courts, and courts, they often try to give more chances for, a filing party to revise their complaint, amend it. Sometimes we'll see First Amendment complaints, Second Amendment complaints, Third Amendment complaints. The courts, often try to give, the filing party opportunity to restate their complaint, to correct and cure any legal deficiencies. I mean, they've already allowed Justin Baldoni, he's already amended his complaint, and there's now a First Amendment complaint that we're addressing here. So I would be surprised if this motion to dismiss were granted, but let's move on. Legal standard. So moving on to the argument, Ryan Reynolds alleges that the claims against him fail under both New York and California law. While the Wayfarer parties appear to agree with Ms. Lively that California law applies to the allegations in the case she filed, that does not answer what law applies to the Wayfarer parties' claims against Mr. Reynolds. The choice of law may vary by defendant and also by specific claim, even against the same party. So that's really interesting, right? So as we know, Blake Lively has filed a claim, and it seems that all parties agree that the California law applies to the allegations in her case against Baldoni. But the choice of law, but this is a different case, right? This is the defendant's case. I'm sorry, this is the plaintiff, Justin Baldoni's case against Ryan Reynolds. So the choice of law may vary by defendant and also by specific claim, even against the same party. So that's important, right? To the extent that there is no conflict between California and New York law with respect to the Wayfarer party's claims against Mr. Reynolds, the court may simply apply New York law. To the extent that there is a conflict between California and New York law, as there may be with respect to the extortion, false light, and negligent interference claims, New York law applies to the claims against Mr. Reynolds because New York is the jurisdiction having the greatest interest in those claims given the way the Wayfarer parties pled the claims against him in the First Amendment complaint. So there's a concept that we need to discuss here. It's called choice of law, right? So when we have different parties, we have the plaintiffs and the defendants, and they're all perhaps located in different states. Blake Lively and Ryan Reynolds, they live in New York primarily. Justin Baldoni lives in California. So there, oftentimes when this happens and you have multiple states involved, people from multiple states involved, there's arguments about what state's law will govern the case. And that is important because certain states have more favorable laws when it comes to certain types of claims. So in New York or in California, it might be easier or harder to state a claim for certain of these claims, such as extortion, false light, negligent interference, et cetera, et cetera. So they're going to fight. They're going to fight about which law applies. And Ryan Reynolds is saying that New York's law should control here. And the First Amendment, so he says the First Amendment complaints allegations as to Mr. Reynolds focus solely on conduct that occurred in New York while he resided in that state. So New York's interest analysis focuses on parties' domiciles and the locus of the tort and applies New York law when complaint contains no factual allegations linking conduct with any other state. Okay, so he's saying, as set forth below, however, each of the claims fail under both New York and California law, and therefore the First Amendment complaint should be dismissed with prejudice against Mr. Reynolds. So when the court dismisses a case with prejudice, it means that the other party cannot refile the same claims. When the court dismisses the case without prejudice, it means that the other party can refile, right? So then it says the court should dismiss all of the 6 causes of action as to Mr. Reynolds with prejudice. So it says the First Amendment complaint fails to state a claim for defamation against Mr. Reynolds. The defamation claim fails as a matter of law. It is fatally deficient because the First Amendment complaint does not identify a single allegedly defamatory statement that was published by Mr. Reynolds, including either of the predator statements. Moreover, to state a claim for slander, a plaintiff must plead a defamatory statement of fact that is false, published to a third party, of and concerning the plaintiff, made with the applicable level of fault on the part of the speaker, either causing special harm or constituting slander per se and not protected by privilege. So that's a lot of different elements that one must prove in order to recover for slander, right? So then the Ryan Reynolds attorneys then say the First Amendment complaint fails to plead the claim in virtually every respect. The Wayfarer complaint does not sufficiently identify any defamatory statements published by Mr. Reynolds. The court should dismiss the defamation claim as to Mr. Reynolds because the First Amendment complaint does not include allegations specific enough to afford him sufficient notice of the communications complained of to enable him to defend himself, right? So in order to state a claim, right, or to state that somebody defamed me, you have to state with specificity what were the alleged comments made, because that other person here, Ryan Reynolds, they need the opportunity and the chance to be able to defend themselves against that your claim, right? and to say, no, I didn't do it. So you need to know in advance what are the allegations that this person is making against me. Okay. So then it says, as to the agent's statement, the First Amendment complaint does not plead what Mr. Reynolds said, when he said it, or any of the context surrounding the conversation during which he purportedly uttered the agent's statement. Paragraph 8, they say, states only that Mr. Reynolds used the term sexual predator to describe Mr. Baldoni during a phone call with Mr. Baldoni's agent. So they're just saying a phrase, sexual predator, was used, but they didn't give any context. They didn't even give like a full alleged statement that Ryan Reynolds had made. And the Ryan Reynolds team says the absence of these details make it impossible, for example, to determine whether this statement falls within the applicable 1-year statute of limitations under both New York and California law for defamation. The sole allegation as to the executive statement provides only slightly more detail, namely that Mr. Reynolds and an unnamed executive at WME had a conversation during a movie premiere shoot about Mr. Reynolds' deep disdain for Baldoni, suggesting the agency was working with a sexual predator. The First Amendment complaint does not allege what precise term Mr. Reynolds used in this alleged suggestion, the sentence in which he allegedly suggested it, or any information about the context of the conversations, other than that one of them was about how much Mr. Reynolds dislikes him for having sexually harassed his wife. Such bare bones pleadings fail to satisfy Rule 8 and warrant dismissal of a slander claim. So he's saying, hey, look, they're alleging that Ryan Reynolds made some suggestion to WME, which is the agency that was previously working with Baldoni, that he was a sexual predator. It seems that they're not even alleging that Ryan Reynolds necessarily definitely said the word sexual predator, but that the allegation is that he made that suggestion, right? He suggested that Baldoni was a sexual predator. He may not have even used those words, right? Because Ryan Reynolds' team's whole point is that Baldoni is not stating with sufficient specificity what allegedly was said by Ryan Reynolds, right? So then we go on to state the predatory statements are not defamatory because they are constitutionally protected opinion. The predator statements are unactionable opinion. So we look here at the law. So Ryan Reynolds' team is citing to certain case law saying, as a threshold matter, because there is no such thing as a false idea, courts must distinguish between statements of fact, which may be defamatory, and expression of opinion, which are not defamatory. Instead, opinions receive absolute protection under the New York Constitution. So the predator statements constitute unactionable opinion because they have no precise meaning. They are not capable of being objectively characterized as true or false, and are merely a general reflection of the speaker's viewpoint. As another court in this district has explained, courts have recognized that words like scum, predators, greedy crooks, and criminals preying on street art culture are vague, imprecise statements of hyperbole considered non-actionable opinions. Well, I would like to read some of those cases because I'm interested in kind of seeing how New York courts have drawn this line, because I actually think, okay, so I understand that predator can be a very vague, open to context term, but the words together, or the phrase sexual predator, that does tend to have a rather specific meaning. So I'm very interested to read those cases and come back and speak with you about that on this channel, because I would like to kind of see how the courts are really distinguishing between the two. So next, we're going to move on to the next part of Ryan Reynolds' motion to dismiss. where he states the First Amendment complaint fails to plead any facts indicating that Mr. Reynolds' statements could be reasonably understood to have been an assertion of fact capable of being proven false, rather than a pure opinion that is not actionable under the law of New York. So the New York courts distinguish between fact and opinion, because a fact is something that is capable of being proven false, right? So next, they point out to some actual cases, federal cases applying New York law, where the court held that calling people predators is rhetorical hyperbole. There's another case, Higgins v. 120 Riverside Boulevard at Trump Place condo, where the court held that calling someone, quote, crazy is a hyperbolic expression of opinion. Another case, in the California appellate court decision, where the court held that calling someone evil, an animal, or shameless is hyperbole. While Mr. Baldoni may not appreciate being called a predator, those hurt feelings do not give rise to legal claims, because name calling, quote, does not reflect a fact, but a non-verifiable view. And then we have Brady v. NYP Holdings, where the court dismissed a defamation claim relating to a statement calling plaintiff a gadfly. Now, it's interesting, and they're saying, the First Amendment principles ought to be obvious to and even celebrated by a group of litigants who have spent most of the past few months calling Mr. Reynolds and his wife bullies and liars. So now they're taking their shots back, right? So we saw that, Brian Freeman and Baldoni's lawyers have taken some, they've taken some shots in their, a lot of shots in their pleadings, some of which are sarcastic. And then it looks like Ryan Reynolds' legal team is now taking that same approach, throwing in some, mutter under your breath, backhanded comments as well. But, what's really interesting here is that I actually think, and I'm going to actually say that it's in this context where Blake Lively filed a sexual harassment, civil rights complaint with the California Civil Rights Department, claiming that there was inappropriate workplace conduct, alleging sexual harassment. I actually think that those facts in these circumstances would suggest that a statement by Ryan Reynolds, if he said it, that Justin Baldoni is a sexual predator, actually would be a fact capable of being proven or disproven, because because Justin Baldoni either engaged in actions that are legally recognized as sexual harassment, or he didn't, right? It's one way or the other. Like, either he did or he didn't. So I think that's a really interesting, if I were on the other side of this, if I were representing Baldoni, I would try to distinguish what Ryan Reynolds' team is trying to do here, which is clever, right? But I would distinguish it and say, no, in this concept, because they're looking at case law that says someone's a predator. It's I argue and I submit that it's very different to call someone a sexual predator. Using those words together does have a very distinct meaning, especially in our culture and in this time of life, right, in this time of our society. And I think that, coupled with the fact that Blake Lively filed that sexual harassment claim with the California Department of Civil Rights, I think that I disagree with Ryan Reynolds' presentation of such a statement as purely opinion, right? So the First Amendment complaint fails to plead any facts indicating that Mr. Reynolds' statements could be reasonably understood to have been an assertion of fact. I disagree with that, just like I just said. capable of being proven false rather than a pure opinion. So Ryan Reynolds' team is trying to say this is just pure opinion. I said, even if Ryan Reynolds said he was a sexual predator, it's just his opinion. But I do think that in this circumstance, if he did say that Baldoni is a sexual predator, I think that it could be reasonably understood to have been an assertion of fact that is capable of being proven false, because there is a sexual harassment claim out there, and it's either going to be that Justin Baldoni, there's either going to be a determination that Justin Baldoni did commit sexual harassment or didn't. Okay, so Ryan Reynolds' team goes on to state, while the First Amendment complaint fails to provide sufficient details about the predator statements, which alone is grounds for dismissal, the limited context it does provide militates in favor of a finding that they are assertions of opinion. The First Amendment complaint alleges that Mr. Reynolds made the predator statements during a phone conversation with Mr. Baldoni's agent and at a movie premiere during a conversation with a WME executive during which Mr. Reynolds was expressing his deep disdain for Mr. Baldoni, which is utterly fatal under the opinion doctrine because it is plainly reflective of Mr. Reynolds' unabashed negative opinion of Mr. Baldoni's character. I also disagree with how they're positioning this as well, because just because you might have a negative, quote, opinion of someone, that doesn't then all of a sudden mean that you're then incapable of making a factual misstatement about someone. So again, they're losing me. So I feel like Ryan Reynolds' team started out this legal motion to dismiss pretty strong. I liked their framework of how they set up the fact that this is not a court of public opinion. This is an actual court of law where the law has to be applied and you have to meet your elements. You have to state all elements of a claim in order to have it survive and move forward in the litigation process. I think that's very valid. I feel like they're kind of going down. I feel like they're going down a road here that is going to lose the court. It's losing me. I'm not persuaded by it. So then they say Mr. Reynolds has a First Amendment right to hold Mr. Baldoni or any man who Mr. Reynolds believes sexually harassed his wife in deep disdain. Right. So again, whether or not he sexually harassed his wife is a fact, right? Either he did or he didn't. Either Baldoni did sexually harass Blake Lively or he didn't, right? So then to call him a sexual predator, if that happened, that is reasonably understood to be a fact that is capable of either being proven false or not. So I disagree in this case with Ryan Reynolds' attorney's positions. Moving along, Ryan Reynolds' team says, and the First Amendment complaint does not allege any plausible facts that would remotely suggest, let alone establish, that anyone interpreted Mr. Reynolds' statements as reflecting anything other than his genuinely held belief about Mr. Baldoni's character. I disagree with that too. So the court should dismiss the defamation claim as to Mr. Reynolds with prejudice because the predator statements are expressions of opinion that deserve absolute protection by law. I do not think that they're going to get this motion granted, in my opinion. The next section of Ryan Reynolds' motion states, if the predator statements are not opinion, they are substantially true. Oh my God, they're substantially true. Okay. So they're saying, hey, look, even if the court finds that this was not a constitutionally protected opinion statement, it's a true statement. So therefore, Ryan Reynolds can make this statement. That's what they're arguing. Even if the predator statements are verifiable as fact, they are not actionable as defamation because they are substantially true. The Second Circuit has held that whether statements are substantially true is appropriate for resolution in a motion to dismiss because falsity is an element of New York's defamation tort, and falsity refers to material not substantially true. The complaint in this case must plead facts that, if proven, would establish that the defendant's statements were not substantially true. A statement is substantially true if the statement would not have a different effect on the mind of the reader from that which the pleaded truth would have produced. So when the truth is so near to the facts as published that fine and slated distinctions must be drawn and words pressed out of their ordinary usage to sustain a charge of libel, no legal harm has been done. It is not necessary to demonstrate complete accuracy to defeat a charge of libel, and all that is necessary is to demonstrate that the gist or substance of the challenge statements be true. So Ryan Reynolds is saying, hey, look, even if this is true, even if it's not determined to be opinion, these are true. He is a sexual predator. Wow, he's like kind of saying, hey, look, he is. And it doesn't mean that I have to prove complete accuracy. I can just allege that the gist or substance of what I said is true. The First Amendment complaint includes numerous references to conduct that a reasonable observer could well consider predatory. In particular, the First Amendment complaint relies on Mr. Baldoni's books, Boys Will Be Human and Man Enough, and his podcast, Man Enough, even going so far as to declare that anyone who knows Baldoni would have knowledge of the contents of Mr. Baldoni's books, relying on statements made on Mr. Baldoni's podcast. So then they cite to a case that says, in ruling on a motion to dismiss, a court may consider documents possessed by or known to the plaintiff upon which it relied in bringing the suit. The court can consider the full text of documents that are cited in, incorporated by reference in, or integral to the complaint. Those materials with which anyone who knows about Mr. Baldoni would be familiar include numerous admissions to behavior that could reasonably be described as predatory. Okay. So then they cite, Ryan Reynolds cites to a case saying that, I'm sure I have crossed. So, he cites to Boys Will Be Human. And he said, saying that, I'm sure I have crossed boundaries and lines in my teens and 20s, not even thinking about it, simply because of the porn that I was consuming. Okay. So then he cites to the Man Enough podcast, where he says, I grew up and had an addiction to porn. I was introduced to porn at 10 years old. I formed these neural pathways in my brain, and it caused me to see the world very differently. Okay. And then it says, A Life of Greatness, Justin Baldoni. They're citing to, again, a work of Justin Baldoni, The Power of Being Enough, Apple Podcasts. And they say, and for me, it was really tricky because I believe that there's a link between rape culture and porn culture. I'm not calling out the porn industry. I'm calling out my relations to it. But I do believe that especially the porn that young boys are watching is very violent. And because we never, no one ever sits us down and teaches us about consent, we learn it through porn. So that was he's also citing from the Man Enough podcast. You, right, as a black man, or you as a woman, have had to put up with a lot of SHIT from people that look like me, or from me your entire life. And again, it could be laundry, or it could be laundry. It could be microaggressions for racism or sexism, whatever it is. I've done all of them. And then Justin Baldoni, they're also citing Man Enough, undefining my masculinity. I wanted as a man to claim her publicly, as on some level I knew it would make me feel more like a man. So they're citing to things that Justin Baldoni has, said, and they're citing the sources and saying like these things indicate that he is even admitting that he has done things that are, predatory. But I don't think that, I don't know, I don't find that persuasive. Me personally, I don't. Let me know in the comments if you do. While it is unclear what predator meant to an average listener, it is quite clear that there is no discernible distinction between the gist of Mr. Reynolds' purported statements and the very behavior to which Mr. Baldoni has repeatedly confessed in public appearances, including that he spent years of his life mistreating women, which he attributes to a lengthy addiction to pornography, as well as openly describing his distorted conception of consent in sexual relationships. Were this case to go to trial, it would be Mr. Baldoni's burden to prove the factual falsity of the supposed allegation that he is a predator, but the law offers no principal basis for a jury to distinguish that label from Mr. Baldoni's descriptions of his own behavior. So then they cite to a case, Second Circuit case, where the Second Circuit found that the Second Circuit is the appeals court, and it's the federal appellate court that handles cases that come up from the New York federal trial courts. And the court found substantial truth where an article called plaintiff an adulterer, because an average reader would understand that term to include the admitted truth that he was a man who unabashedly committed adultery for 13 of the last 17 years, and whose adulterous behavior ended only because his wife ultimately divorced him, right? And then they're citing to other cases as well. Statement was found substantially true, where its thrust was the same as the admitted truth. Finding statement describing plaintiff as a physically abusive drug addict was substantially true, given plaintiff's own admissions about physical abuse. So actually, you know what? That argument is much more persuasive. That argument is more persuasive because Ryan Reynolds is saying Justin Baldoni has admitted that he has mistreated women for a great majority of his life and that he had misconceptions about sexual consent. So Ryan Reynolds is saying, hey, look, even if I did make that statement that he's a sexual predator, it's no different than the gist of the statements that Baldoni has made about his own self. And that's a very persuasive argument, I think. So then moving along in the complaint, he states it would be perverse to permit Mr. Baldoni to build an entire brand complete with a podcast, TED Talks, and books off of his confessions of repeatedly mistreating women, only to turn around and sue Ryan Reynolds for $400 million for simply pointing out in private what Mr. Baldoni has bragged about in public. So that's a really interesting statement because remember, the statements that Ryan Reynolds allegedly made were made in private settings, either on a phone call with the agency or also to a WME rep at the premiere. So, Ryan Reynolds is saying, hey, look, I didn't publicly put this out there about him. I was making statements. And then, of course, Baldoni's attorneys would say, well, it's only necessary for defamation that you disseminate the statement to one other party. It could be any third party. It doesn't matter if you said it on a phone call. You still disseminated a statement that's factually untrue to someone other than Justin Baldoni. So next. Then they state that in light of Mr. Baldoni's own public admissions, of which the court can take judicial notice, excuse me, the substantial truth doctrine requires dismissal of Mr. Baldoni's defamation claims as to Mr. Reynolds. So he's saying the court is required to dismiss these claims. Then Ryan Reynolds goes on to state the First Amendment complaint fails to plead special damages. So the dismissal of the defamation claim is warranted because Baldoni's complaint does not allege defamation per se, but nonetheless fails to fully and accurately plead special damages with specific particularity to identify actual losses. So again, this is an essential element of the claim. And Ryan Reynolds is saying that Justin Baldoni did not even state that or allege that in his First Amendment complaint. This particularity requirement is strictly applied as defamation claims will be dismissed for failure to allege special damages with the requisite degree of specificity. So, moving on to the next page, Ryan Reynolds' team goes on to say the First Amendment complaint fails to plead facts that demonstrate actual malice. As a public figure, Mr. Baldoni must plead facts demonstrating that Mr. Reynolds uttered the predator statements with actual malice. In other words, that Mr. Reynolds, in fact, entertained serious doubts as to the truth of his publications. However, the First Amendment complaint's conclusory assertion that the lively parties, which are defined to include Ryan Reynolds, knew the statements were false or had serious doubts about the truth of the statements is a threadbare recitation of the legal element that is insufficient to sustain the law's heavy burden on defamation plaintiffs. So what he is saying, Ryan Reynolds' team is saying that he doesn't even, Ryan Reynolds is saying that, again, he didn't act with actual malice. He believed that Baldoni is a sexual predator. He says, hey, look, I mean, Ryan Baldoni acknowledges all of these very troubling things, you know, on his own podcasts, in his own book. So he's saying he didn't make these statements with actual malice, which is a requirement. So then on the next page, Ryan says, it would be inconsistent with the First Amendment complaint to find that Mr. Reynolds uttered the predator statements with actual malice. Indeed, there is not a single plausible factual allegation from which a jury could conclude that Mr. Reynolds does not believe Mr. Baldoni to be a predator. To the contrary, the First Amendment complaint alleges that Mr. Reynolds took steps consistent with believing his wife's allegations, including demanding an apology from Mr. Baldoni and mocking Mr. Baldoni's woke feminist facade in Deadpool and Wolverine, not to mention Mr. Baldoni's own public admissions about his past conduct. The deep disdain that the First Amendment complaint alleges Mr. Reynolds feels towards Mr. Baldoni concedes that Mr. Reynolds subjectively believes what he said about Mr. Baldoni and thus defeats a finding of actual malice. So they're saying, hey, look, he actually did believe, Ryan Reynolds actually did believe this about Justin Baldoni. And, you know, his statements are not defamation. And then Ryan Reynolds' team says, the predator statements refer solely to Mr. Baldoni and not any of the 6 other Wayfarer parties. To the extent that the First Amendment complaint intends to assert the defamation claim on behalf of any defendant other than Mr. Baldoni, it requires dismissal because the predator statements are not of and concerning any of them. Right? So again, another good argument because the defendants collectively asserted this claim of defamation against Ryan Reynolds instead of specifying that only Justin Baldoni was bringing these claims, right? So the Wayfarer complaint fails to state a claim of false light. The First Amendment complaint fails to state a claim of false light as a matter of law under either New York or California law. There is no tort of false light invasion of privacy under New York law, and the court need not engage in any further analysis in order to dismiss such a claim. While California law does recognize claims of false light, dismissal also is required when, as here, the claim for false light invasion of privacy is duplicative of a defamation claim. While the First Amendment complaint's false light claim suffers from the same fatal lack of specificity described above, which alone requires dismissal, it also fails because it appears to rely entirely on the alleged public disclosure of information on which a defamation claim is based. Finally, even if all of that were not dispositive, the false light claim fails as a matter of law for all the same reasons the defamation claim cannot survive dismissal. So they're basically saying Baldoni also did not meet his pleading requirements to be able to sustain a claim for false light and invasion of privacy against against Ryan Reynolds. The Wayfarer complaint fails to state a claim for civil extortion. The civil extortion claim against Mr. Reynolds must be dismissed because New York law does not recognize extortion as a tort or as any private right of action, right? So again, Ryan Reynolds is saying New York law governs because of the way that Justin Baldoni pled this case and pled his elements and stated facts. Similarly, although California federal courts have divided over whether California recognizes a civil cause of action for extortion, The most that California's state courts have recognized under the heading of civil extortion is a cause of action for the recovery of money obtained by the wrongful threat of criminal or civil prosecution, where the threat of prosecution is made with the knowledge of the falsity of the claim. Because that cause of action is a form of fraud, it must be pleaded with particularity under Rule 9b. The First Amendment complaint is devoid of any allegations, much less particularized allegations that Mr. Reynolds obtained any money or property from any of the Wayfarer defendants or made any wrongful threat of prosecution, much less with knowledge of the falsity of the claim. And the same is true using the borrowed elements of criminal extortion. The First Amendment complaint fails to allege that Mr. Reynolds either obtained any property or consideration from any Wayfarer defendant, because of course he did not, or did so through a wrongful use of force or fear. Okay. So then it says the intentional interference claims must be dismissed as well. And then Ryan Reynolds' team is setting out the reasons why they feel that those intentional interference claims also failed to meet their legal elements. It says, as an initial matter, each of the tortious interference claims must also be dismissed as duplicative of the defamation claim. New York law considers claims sounding in tort to be defamation claims, where those causes of action seek damages only for injury to reputation, or where the entire injury complained of by plaintiff flows from the effect on his reputation. The next assertion that Ryan Reynolds makes is that the First Amendment complaint fails to state a claim for intentional interference with contract. He again talks about the differences between New York law and California law as it relates to this cause of action, and he sets forth the fact that he alleges that Baldoni has not properly pled this cause of action. Then we say he also goes on to state that Baldoni does not state a claim for intentional interference with prospective economic advantage. And when we're talking about like interference with prospective economic advantage, these are really claims where they're saying he harmed, Baldoni is saying that Ryan Reynolds and his allegedly defamatory statement harmed his ability to make money and harmed his ability to economically benefit. So to state such a claim, the plaintiff must allege that it had a business relationship with a third party. The defendant knew of that relationship and intentionally interfered with it. The defendant acted solely out of malice or used dishonest, unfair, or improper means, and the defendant's interference caused injury to the relationship. Once again, the sole economic relationship alleged in the First Amendment complaint is between the Wayfarer parties and WME, which is the agency that used to represent Justin Baldoni, without specification as to which of the Wayfarer parties had such a relationship. So the First Amendment complaint does not even attempt to allege that Mr. Baldoni acted solely. The First Amendment complaint does not even attempt to allege that Mr. Reynolds acted solely out of malice, as it is required to survive a motion to dismiss. But the First Amendment complaint itself asserts that Ms. Lively and Mr. Reynolds were motivated at least in part by a desire to seize control over a film production. So taking that allegation as true, as the court must at this stage, whether or not it is true, such a motive akin to normal economic self-interest is inconsistent with the sole purpose of inflicting an intentional harm and inconsistent to state a claim for tortious interference with prospective economic advantage. So that's very clever what Reynolds' lawyers did here. They said, hey, look, Justin Baldoni says that Blake Lively and Ryan Reynolds had at least partly their actions were motivated by their desire to take over the film. They wanted to seize and control the film. So that's their actions are not solely based on just wanting to inflict intentional harm. So they're taking Justin Baldoni's allegations and the words that he has used in his pleadings and using it against Justin Baldoni to say, this is why you can't survive. This is why this claim of yours cannot survive. So then the First Amendment complaint fails to state a claim for negligent interference. The negligent interference claim must be dismissed because there is no claim for negligent interference with prospective economic advantage under New York law. And then Ryan Reynolds says the First Amendment complaint fails to allege proximate cause. Each of the tortious interference claims must also fail because the First Amendment complaint does not allege that Mr. Reynolds' alleged conduct proximately caused WME to cease performance, right? So then they cite some cases finding the tortious interference claim failed, where there was no allegation that defendant's conduct proximately caused the third party to sever its business relationship with plaintiff, right? So the Wayfarer parties have failed to allege any damages. And finally, damages is an essential element of these claims, and Justin Baldoni has not sufficiently stated a claim. Stated that element is what Ryan Reynolds' team is saying, right? So the final part of this says the Wayfarer complaint fails to allege conspiracy liability. Having failed to allege any plausible claim based on Mr. Reynolds' conduct, the First Amendment complaint attempts to hold him liable on a conspiracy theory. That attempt fails. Under both California and New York law, a civil conspiracy theory requires that a plaintiff allege an agreement to participate in an unlawful act or a lawful act in an unlawful means, an overt act performed in furtherance of the scheme, and an injury caused by the overt act. Conclusory allegations do not suffice to survive a motion to dismiss. A complaint must contain more than general allegations in support of the conspiracy. Rather, it must allege the specific times, facts, and circumstances of the alleged conspiracy. Here, the First Amendment complaint pleads no specific facts indicating the necessary agreement among any parties, any overt acts done in furtherance of such an agreement, and any damages. Even under the liberal pleading standards of Rule 8, a complaint must do more than assert that the defendants agreed to commit a tort, right? And they cite some case law in support of their position. So read inadvertently or as a whole, the First Amendment complaint's allegations that Mr. Reynolds participated in a conspiracy to engage in tortious conduct against any of the Wayfarer plaintiffs are utterly conclusory. They amount to bare assertions. Asserting that Ms. Lively, working with her husband, conspired to harm the Wayfarer parties by advancing a narrative in the press. Unsupported speculation, where they allege that Mr. Reynolds apparently joined a campaign to extract concessions and creative control over the film. And pure boilerplate reciting elements of civil conspiracy liability. So they're citing the fact that, which I agree, the complaint of Justin Baldoni appears to be bare and bald of any actual facts that would support a conspiracy theory, right? There is accordingly no base to hold Mr. Reynolds liable on a civil conspiracy theory for any of the conduct alleged in the First Amendment complaint. It says the court should award Mr. Reynolds attorney's fees pursuant to New York's anti-SLAPP law. Mr. Reynolds is entitled to attorney fees under the substantive fee shifting provision of New York's anti-SLAPP statute, which applies to the First Amendment's complaints and allegations against Mr. Reynolds for similar reasons to those articulated in the Sloan and NYT motions to dismiss, both of which Mr. Reynolds joins and incorporate by reference. So essentially, Section 70A mandates a fee award to Mr. Reynolds' favor because, as discussed above, the First Amendment complaint asserts causes of action against him that are based on communications and conduct in furtherance of an issue of public interest, namely Mr. Baldoni's and Mr. Heath's harassing workplace conduct and the subsequent retaliation, and cannot survive a motion to dismiss for failure to state a claim. So that's interesting, right? So New York civil rights law, Section 70A1, which applies to the First Amendment complaint's allegations against Mr. Reynolds for similar reasons to those articulated in basically Section 70A applies in federal court because it creates a substantive cause of action for attorney's fees. It mandates a fee award in Mr. Reynolds' favor. And the First Amendment complaint asserts cause of action against him based on communications and conduct and furtherance of an issue of public interest. And he's saying, our law protects against us being sued for speaking out about a matter of public interest, which was the alleged sexual harassment that was going on in that workplace. Although this court reached a seemingly different conclusion in Brady v. NYP Holdings, Inc., Mr. Reynolds respectfully submits that the reasoning of the other case, rather than Brady, should control here for 3 reasons. So he's distinguishing, this is interesting. So this particular court, right, they're in a federal trial court in New York. This court has previously ruled in a different way than what Ryan Reynolds is asking the court to rule here. So he's seeking to distinguish that prior case from his own case, and he's delineating 3 reasons. So in conclusion, all claims against Mr. Reynolds should be dismissed with prejudice and without leave to amend, and the court should award Mr. Reynolds his costs, including attorney's fees, incurred as a result of the consolidated action. So, oh my heavens, the attorney's fees must be mounting for these people. I mean, yes, I realize they're fabulously wealthy, but even with all of these motion filings and all of this ongoing litigation, it must be incredibly costly. So again, friends, thank you all for tuning in with me. Subscribe to the channel to help support our channel grow. We come to you with live streams on all of the breaking entertainment and celebrity news and lawsuits, delving into real legal pleadings. So kindly subscribe. We've been covering the Vanderpump Rules litigation. We've been covering the Tony Busby, Jay-Z, Sean Diddy Combs legal saga. We've also been covering, of course, the Blake Lively and Justin Baldoni legal saga. So thanks so much, guys, and I'll see you back again for our live stream later on this week.